Sorry about this. I set the alarm to go off at 11:50 p.m., not 11:50. I mean 11:50 a.m. and not. Anyway, I got it wrong. So what we're going to do is we're going to start streaming, and we'll put it at 1.25 to see if we catch up. So, um, yeah, I was taking a nap, and my friend called and woke me up, and I discovered that the alarm didn't go off because it was set for late night instead. Okay, so let me grab the video feed here. Um, okay, I'm just looking for where they come back. Okay, so oops. Let's make that smaller. We need to share the screen first, then we can make it full screen. Okay. All right. Now let's 1.25 full screen. Okay, let's see if we can get.
Please have a seat. Thank you. Thank you. Welcome back. As you know, we have had to discharge one of the jurors as a result of the disability of that juror from sitting or continuing to sit as a juror. And under 3629 of the Code of Criminal Procedure, we have acted in accordance, and the first alternate that was called during our jury selection officially replaced that juror and is now a juror in the case, and will stay on through deliberation. Very well. You have already been sworn in along with the rest of the jurors, so we do not need to swear you in to any other oath. You've already taken the oath. Okay. There has been no objection from any of the parties. And I'll ask once again from the state side, there is no objections. Is that correct? And from the defense? Thank you. Very well. Let's proceed. And I know we had under cross-examination, Dr. Cunningham. He is, let me see, lower my screen. He is on and will be spotlighted along with counsel for the state and the defense. Brendan is on. Thank you. You may proceed when ready.
Thank you. Good afternoon, Dr. Cunningham.
Good afternoon.
Again, my name is Marisela Jackman, and I'm prosecutor for the state. And I wanted to, since we had a little bit of finish with the opinion that you stated yesterday regarding the sentencing issue at hand, because this is a death penalty case. And can you hear me?
I can, thank you.
Okay. Were you able to hear what I just said?
I was, thank you.
Now, you gave an opinion yesterday as to the probability of Mr. Ronald Anthony Burgos-Aviles, the future danger or the likelihood, and as you put it, the probability of him committing future acts of violence. And I believe your testimony was that he is quite unlikely to commit serious violence in TDCJ. And you also said he is less likely to commit serious violence in prison than other inmates and other capital offenders. And I'd like to discuss that with you today.
One second. That's as far right as it goes. In other words, the only thing I can see is the almost.
Now, Your Honor, just for housekeeping rules, will the court allow us to use the exhibit that was introduced yesterday? Will Dr. Cunningham be controlling it, or will we be allowed to use it? Okay, thank you.
You have it on your computer?
Yes, Your Honor. Now, Dr. Cunningham, statistically speaking, if you had assessed Ronald Anthony Burgos-Aviles on the morning of April 9th, 2018, the day of the murders, he would have been a low risk for violence, correct?
If he had not been contemplating the tragic death of these two victims, he would be a low risk of violence. Obviously, if he had been contemplating that already and was assessed and was candid about that, he would be a marked risk of violence.
Okay. And so the purpose of you saying, or the reason you're saying, if there had been some evidence of premeditation, then that would have been a higher risk, correct?
That's correct.
Now, because we know, even though the factors that were used by you when you decided to consider the base, I'm not sure how you put it, base stats, and you have this, it is on your slide 18 when you said, the knowledge of the appropriate base rate is the most important single piece of information necessary to make an accurate prediction. Is that what you meant by you need to consider stats that are based on similar characteristics as Mr. Ronald Anthony Burgos-Aviles, correct?
Broadly similar, that's correct.
Yes.
So that if we said we've got a 29-year-old law enforcement officer without a criminal record, what's the likelihood he will murder someone today?
Right.
That likelihood would be extraordinarily small. There may be other factors that you would feed in the midst of a domestic dispute or a child custody dispute with pending child support, with the knowledge of this not being known to his wife. It may be as you build in some additional factors that risk would increase. But on a broad demographic, you would identify that he was at low risk.
Yes. And now we know that he did in fact commit 2 murders on that day, even though statistically speaking, he was a low risk, correct?
Based on those broad demographics, that's correct.
Right. Now, which leads me to the idea that, and I believe you stated in your book, that it is important and the law requires that we have an individualized assessment of the defendant in a death penalty case. Is that correct?
Yes.
Okay. Now, did you conduct an interview of Ronald Anthony Burgos-Aviles?
I did not.
Now,
I individualized this to him based on other information and other factors.
will you state what evidence, what information you used so that you could individualize that?
His jail records, his employment records, about 3 hours of the interrogation video, information provided to me by the defense regarding his education level. That was the basic fund of information. And of course, many studies.
And by the many studies that you're referring to are the all the information, all the studies that you provided yesterday regarding statistics that included Missouri, Arizona, Florida, federal cases, correct?
Oregon, Arizona, some data nationwide. That's correct.
Now, when you are conducting a study based on stats or statistics, it is important to make sure that the underlying base, or as you put it, the base rates, that they are similar to whatever it is that you're comparing to, correct?
I'm not sure I'm tracking the question. Obviously, you want your data that you're basing the comparisons on to be as accurate and complete as possible.
Yes, and you also want them to be consistent. For example, you would like that the underlying defendants or convicted murders in those jurisdictions should have been similar to the standards that are similar to what the jury needs to assess, correct?
Oh, no, ma'am, that's not particularly correct. We made comparisons of state prison inmates broadly. He will be a state prison inmate. We made assessments of inmates facing life sentences. He will be facing a life sentence. We made comparisons of persons in higher security. He will be in higher security. We made comparisons of individuals convicted of homicide. He's been convicted of homicide. We even made comparisons of persons with multiple domestic homicides. And so it's not essential that the exact sentencing procedure be in place in order to make meaningful comparisons.
So, but that would be your discretion, and because you don't know exactly the terminology or the how they kept records. So for example, and I'm going to give one example where I know that one of your stats discussed the type of violations that would occur in a particular study, and there was an indication that violence did not include threats, or the violence that was reported, it would not be reported if there was consensual fights between two consenting adults. Is that correct? In some situations that the reporting may be different in different jurisdictions. Is that a proper statement? Yes or no?
No, ma'am, I don't think that's accurate. Broadly, I talked about a range of disciplinary infractions that included threats, and in most of our studies, we captured that information. The sorts of things that are against the rules in Texas are against the rules in every state prison jurisdiction. It isn't as if somehow Texas has special rules about assaults that other jurisdictions don't.
Exactly, but like you said, similar. They're not the same, and so it would have been a more compelling argument if you would have used statistics from the state of Texas, using the same type of assessments that you had done from other jurisdictions, correct? It could have been.
Ma'am, I extensively described Texas studies. I described other jurisdictions as well. The findings are quite consistent across those different jurisdictions, and it's broadly regarded in the field of penology or prison science that these results generalize from jurisdiction to jurisdiction, particularly across the state prisons.
Okay, now let me ask you this. You have been retained by the defense as an expert witness, correct?
I was.
And are you getting paid for your testimony?
I'm paid for my time.
Okay, and is that on an hourly basis?
Yes.
And your duties, what does that cover for you when you are providing the services, in addition to reviewing the video statements? What other things are covered with your duties?
Objection to the form of the question, Your Honor. I didn't understand it.
What?
If you understood it, thoughts are coming in. If you'd like some clarification, like that.
I think I understand, Your Honor. So professional duties for a psychologist are broad and detailed across many different arenas. So you could consult both the ethical guidelines and code of conduct for psychologists, and also the specialty guidelines for forensic psychologists. So there are extensive obligations that a psychologist has in undertaking a professional consultation or evaluation.
In particular, in this case, for the punishment or the capital sentencing phase of this trial, correct?
Yes, ma'am. The graver the implications, the more important the obligations.
And in your book, Evaluation for Capital Sentencing, you describe the different roles that a psychologist may take. And it's in on page 112 of your book, and you describe that there are different roles that a forensic psychologist can take. And you said direct evaluator, indirect evaluator, and a teaching witness, correct?
Yes.
And you also emphasize the importance, because this is a death penalty case, on individualizing the evaluation on particularly regarding Mr. Ronald Anthony Burgos-Aviles. That is critical for a true and compelling opinion on whether or not he is a future danger or the future dangerous issue, correct?
No, ma'am, the book doesn't address this defendant at all, and it was written a decade ago, and so it doesn't address him specifically. It does talk about the importance of doing a thorough evaluation of adverse developmental factors, mitigation in the defendant's background, even going back several generations, to very thoroughly explore that. And for the violence risk assessment for prison to be informed by the best available science.
Yes.
And if presented, if either of those are presented as a teaching witness, there might only be a description of the underlying science. Alternatively, there may be a description of that underlying science that is individualized to a specific defendant based on records or interviews of family or other people. It may include even being based on an interview with the defendant. So those are those three levels. All of them include the science. Another one includes the science plus particularizing it based on information that's gained about the defendant without interviewing the defendant. And then the third potential is the science, the records and other sources, and an interview with the defendant.
And I believe in your book, you stated the most complete individualized evaluation includes review of records, interviews of third parties, and direct interview assessment of the defendant. And in light of that, direct evaluative contact with the capital defendant is considered the best practice and should be requested by the mental health professional in all cases. Now, yesterday, when Mr. Boggs asked you what was requested of you, did you, in light of your statement in your book, ask to give the best, or as you put it, the best practice so that you can implement the best practice? Did you request to have direct evaluative contact with Ronald Anthony Burgos-Avilles? Yes or no? It's a simple question.
I can't answer that question yes or no the way you phrased it.
So in the statistics that you used, these did not include particularized characteristics that Mr. Ronald Anthony Burgos may have, correct?
That's totally incorrect.
Now let me ask you then. Did your statistics take into consideration issues such as did it take into consideration the level of deception that the jury, that's in evidence, that was part of the things that you reviewed, because you reviewed the video, correct?
I did. Not in its totality. I think he was actually interviewed for about 12 hours. He was in the room for about 12 hours. I testified that I observed several hours.
Objection, non-responsive, if he can, he's
responsive. I believe it was responsive, directly responsive.
You said that you interviewed, you want to maybe approach for a second? Now, in the sections or the part of the interview that you reviewed, was at the beginning of the interview?
Well, yes, ma'am. It began with him being sitting alone in the room for some period of time. I skipped through that pretty rapidly, and then the two officers came in to interview room 2 and interviewed him Most of the time, two of them, sometimes one of them.
Now
Wait for the next question.
I'm going to ask you, I will ask you a specific question and ask you to limit your answer to answering my question. And if you feel that you need to add information, you can wait until Mr. Boggs asks you regarding whatever it is that you'd like to add.
No, ma'am, I took an oath to tell the whole truth, not the whole truth if I was then asked a clarifying question on redirect. So I will answer in a way that I believe reflects the whole truth.
Well, then let me ask you, did you skip through the first part of the interview and not view Mr. Burgos-Aviles' conduct while he was waiting to be interviewed? Yes or no? Did you view that?
Only in spots did I review him sitting in the room alone.
Did you see his behavior where he was biting his nails?
I observed him biting his nails at another time in the interview when he was sitting alone.
Did you see him licking and rubbing his arms and under his shirt and unbuckling his belt as though he's looking for something?
I did not.
Did you see him whispering or rehearsing some sort of lines?
Judge,
I did
object to the
not.
characterization of the evidence. The evidence speaks for itself.
Let's rephrase it. I think you
Did you see his response when he was faced with the facts of what was presented that day? That the victim was there, and she was there, and it was known she was going to meet Anthony Burgos with a child at the park, and it was a Border Patrol agent. And faced with that his response was that it was a major coincidence. Did you see that part?
I didn't see the first confrontation. That was not among the tapes that were provided. I did see that discussion in subsequent aspects of the interview where he was denying that they had planned to meet.
And did you see how his concern was not the two individuals that had just been found dead, but his concern was that he was embarrassed because he was arrested and wearing his Border Patrol uniform?
I don't recall the expression of embarrassment. I do recall in that interrogation that he was focused on that process of being accused as opposed to the victims.
Are you aware that these crimes occurred while he was in his uniform
Yes,
and he was in a kilo unit belonging to the Customs and Border Protection,
yes,
and that he reported finding the bodies using property that belonged to Border and Customs?
yes.
Now I'm going to go back to your slides, but before I do that, I know you mentioned that you have a legal and ethical duty as a forensic psychologist, and I believe you are subject to specialty guidelines for forensic psychology, and you're very familiar with those.
I can't answer that question yes or no. There's not a legal obligation under the specialty guidelines. There's not even necessarily an ethical obligation under the specialty guidelines because those are aspirational in nature, but they do reflect an aspirational standard that psychologists should seek to uphold, and I do as well.
And so I'm going to be directing my attention to specialty guidelines for forensic psychology adopted August 3rd, 2011, section 902, and it's entitled Use of Multiple Sources of Information. And it states, forensic practitioners ordinarily avoid relying solely on one source of data and corroborate important data whenever feasible. When relying upon data that has not been corroborated, forensic practitioners seek to make known the uncorroborated status of the data, any associated strengths and limitations, and the reasons for relying upon that data. Now, when you testified yesterday, did you believe it was important to say that part of the individualized aspect of your opinion is that you, even in your book, recommend a direct examination of the defendant?
I am unable to follow the question entirely, and also it's compound, so that I can't simply answer yes or no.
Do you recommend in your book that the best evaluation is to have a discussion or an interview with the defendant? Yes or no?
Ma'am, No, I don't think that's how it's characterized in the book.
And
If you'll direct me to a page number, I'll get my text off the shelf and we can both turn to it.
it's on page 112 under application. And
If
it's
you mind if I step up to get my book off the shelf?
absolutely, that's fine. Now, it says, it's discussing individualizing the evaluation, it's in bold. And then it says, though all three of the potential expert roles, and that's referring to the direct evaluator, indirect evaluator, and teaching witness, correct? Yes or no?
Yes.
Involves foundational science testimony. They differ in the extent to which the expert individualizes this research to the defendant's history. The most complete.
No, ma'am. No, ma'am. You've skipped through a parenthesis there in that line.
Individualizes, applies with specificity this research to the defendant's history. The most complete individualized evaluation includes reviews of records, interviews of third parties, and direct interview assessment of the defendant. Is that how it's written in your book? Yes or no?
That's correct.
Thank you. And so you do say that such, and I'm going to skip down about 7 lines. It says, such direct evaluative contact is essential for neuropsychological assessment or psychological.
Let me catch up to the 7 lines. Yes, such evaluative contact is essential for neuropsychological assessment or psychological testing,
as well as to describe contemporaneously observed psychological characteristics or establish a current psychological diagnosis. Correct?
Yes.
Then it discusses some of the things that can be discovered by a forensic psychologist, and we don't need to go through that. I want to go down to, in light of the above, all the things that can be viewed by a forensic psychologist that would be pertinent to discovering or for giving an opinion as to future danger.
No, ma'am. Look, should direct me exactly where you are.
I'm going to. It's
because I don't mention future. I don't say the term future danger in this text, except to clarify that that's not the issue.
Well, then go back to the previous page where it says forensic mental health.
You need to tell them exactly where so we can follow along. So you can follow along, otherwise you're gonna have delays in the testimony. Tell them exactly.
So on the previous page where it says,
Sorry, try not to talk over me, please. The page number where you're at in the paragraph 9.
page 112, where it says info,
Oh, in the text box.
it says forensic mental health professionals may perform one of the following 3 roles at capital sentencing trials.
Yes.
So this
And then it
is,
specifies the 3.
yes, sir.
Doesn't say future danger.
But it is referring to capital sentencing trials, correct?
Yes, ma'am. At this point, primarily
Thank
focused
you.
on evaluations of mitigation.
Objection,
but
Your
also
Honor.
potential
Non-responsive.
violent risk assessment for prison.
Wait for the question. Thank
In light of the above, and now I'm going to the next page, which is 113. And it's
Let me catch up. Hold it. Which line on 113?
6 lines up. And it's
Yes,
6.
I see that.
Thank you. In light of the above, direct evaluative contact with a capital defendant is considered the best practice and should be requested by the mental health professional in all cases. Is that in your book? Yes or no?
It is, yes.
Thank you. Now, I'm going to now refer to your slideshow.
Go ahead and share screen, is that fine?
you. It's already ready for you to share.
Are you able to see this, Dr. Cunningham?
I am, thank you. I am, thank you.
Thank you. to refer to your slide entitled Risk Assessment Techniques. And you give a weight and you say the more scientific assessment techniques are the actuarial, which is the group statistical. And yesterday you testified that's the insurance company method. And then I believe the arrow pointing down is indicating that it becomes less scientific as with number 2, the past pattern behavior. The third one is intensive clinical evaluation. And then 4 and 5 is it's a hypothetical inference. And then 5 is when you gave the example, I believe, of the flying an airplane, correct? Am I on the right page here?
Yes.
Okay. Now,
not of flying an airplane, but of billboards of airline crashes in airport concourses.
okay. And so you yesterday were referring to, during your testimony, to the actuarial, which is a group statistical information, correct?
That and the past pattern approach.
Now, isn't it true that if you had the actuarial and the past pattern of behavior and, as you stated in your book, the intensive clinical evaluation of Mr. Ronald Anthony Burgos-Aviles, that would be a more comprehensive interview or a comprehensive evaluation and assessment of the future dangerousness issue?
No, ma'am. There is no future dangerousness issue. There is a special issue of a probability of acts of a certain severity that would constitute a continuing threat to society. There is no future dangerousness issue.
Okay, then if you had the actuarial, the past pattern of behavior, the intensive clinical evaluation, if you had those 3 risk assessment techniques, you would better, and it would be a more compelling opinion that of determining whether Ronald Anthony Burgos-Aviles, if there was a probability that he would commit criminal acts of violence that would constitute a continuing threat to society. If all 3 of these assessments were used, would that be a more comprehensive and more compelling opinion?
I can't answer that yes or no, but I could make a brief clarification.
Would using the intensive clinical evaluation have complied with the individualizing the assessment that you provided yesterday? Yes or no?
I did individualize the assessment yesterday, so I can't answer that question yes or no the way you phrased it without being misleading.
My question is, would an interview of Ronald Anthony Burgos-Aviles provided?
Judge, objection, this is just badgering. He's answered the question that it's impossible the way it's phrased without it being misleading.
I'm trying to rephrase it, Your Honor. Would your interview of Ronald Anthony Burgos-Aviles provided personality characteristics that would have been pertinent in your assessment for determining whether the probability that Mr. Burgos would commit criminal acts of violence that would constitute a continuing threat to society?
No, those personality characteristics would not have been informative of that. There is history, had he been candid about it, that would have been informative of his risk in the very short term, like over the next couple of weeks. And that would have included that he was using testosterone and phentermine and an anti-estrogen compound, those things associated with elevating the risk of impulsive aggression and unwanted aggression. Had he been candid about his potential child support payments and not having revealed the presence of a loved child to his spouse and the jeopardy that this might be, the combination, and had he been candid about his frustrations or anxieties, that would have been, all of those things would have informed an assessment, had he been candid about them, of his risk within the next couple of weeks. Not his long-term risk and not about his personality characteristics, but rather about the particular context that was driving and working on him at that time.
But Dr. Cunningham, you did not interview him, so you don't know if he would have been candid. Yes or no?
Don't know that he would have.
I'm going to direct your attention to the sentencing considerations that we discussed, or that you discussed with Mr. Boggs yesterday. And you mentioned that the first 2 you did not want to discuss because that was within, believe you said, up to the jury. Is that a proper statement?
Well, it's not that I didn't want to discuss them. It's that I'm here as an expert, and experts and psychology experts have no particular expertise in what punishment a given offense calls for, or general deterrence in terms of a message that's sent to larger society. So those are legitimate questions. They're just questions for a jury and a judge. They're beyond the pay grade and expertise of a psychologist.
And you are aware that the law provides under 37071 that the law provides that the jury may consider evidence of the defendant's background. Yes?
Yes. Yes.
Character.
Yes.
And the circumstances of the offense.
Yes.
And even though you testified yesterday that statistically, the facts of the case, however heinous they may be, do not have a bearing statistically as to whether the probability that Mr. Ronald Anthony Burgos would commit criminal acts of violence that would constitute a continuing threat to society, correct?
The severity of the offense does not predict that, including having killed 2 victims.
And
as he is going to be confined for life in prison.
Yes. And so again, even though statistically that is not considered I believe a risk factor of for special issue number 1, it is something that can be considered by this jury who's listened to the facts and the evidence to apply the proper punishment, correct?
Well, yes, ma'am. I'm not speaking about the punishment.
Give me a second.
The state is conflating and confusing the 2 different special issues.
Approach, please.
that the fact that there was more than one person that was killed, that it was irrelevant to your operational or to your statistical finding or assessments. It was limited to that, correct?
Objection. The question was.
Yesterday you testified that let me see if I can find it. I won't go to that. I'll find it real quickly. Do you recall the testimony regarding more than one person's death and how that was not considered relevant in your statistical findings?
No, ma'am. I never testified it was not relevant. I testified that it was a factor to consider. In one of the studies that I cited, I identified that there was not a statistical difference in the prison misconduct of homicide offenders who had killed one person versus who had killed two persons. Then on slides 102 and 103, I cited a study that compared offenders who had killed more than one person in a domestic homicide context to about 14,000 other homicide offenders in the state of Texas who had killed only one person, and identified that those that had killed multiple people in a domestic homicide were dramatically lower. If you go to slide 103, we can depict that. They were dramatically lower in terms of level 1 violations and assaultive misconducts. Once you got out to those with injuries, they both had very low rates. So that was a factor that I looked at, reported on. So it's not fair to say I said it was not relevant. It was not predictive of an increased risk of violence in prison. And with multiple domestic homicides was even associated with a lower risk of level 1 and assaultive misconduct.
Now,
but again, that's reflected in the bar graphs on 103, if you want to go there.
I'm going to go instead to slide 99, where and it's entitled, "Are capital offenders who have killed multiple victims more violent in prison?" And you said this offense feature was not associated with an increased prison violence. Is that how you testified yesterday?
That's correct regarding that study. There were two other studies that I then described.
Now, do you know that this was not a domestic crime?
Objection to mischaracterization of the evidence, Judge.
I would characterize this as a domestic crime, as it involved the homicide of an intimate and the associated child of that union, however, out of wedlock.
Now, I'm going to go to your slide number 7. And you gave us two definitions of probability. One was more likely than not. And the second one is disproportionately likely as compared to other defendants, correct?
Yes.
And when you described the second definition of probability, you said that this was your psychological operationalized definition, correct?
No, ma'am. I said these are two operational definitions of probability that I was making use of as a forensic psychologist and are as employed by violence risk assessment experts.
And the psychological, what is the proper term? Psychological operationalized definition? Is that how
I wouldn't call it psychological. I would simply call it two operational definitions of the term probability.
And the reason we have this operationalized definition is so that you can have some sort of measurement, correct?
That's one of the reasons, so that you can measure it. It's not the only reason, it's one of them.
Okay, it's one of them. In particular, because we're talking about statistics.
Well, because we're talking about likelihood. And so we need to describe what likelihood means. The special issue uses the term probability. As I'm involved in assessing that probability, I need to operationally define the terms involved.
Yes, and that applies to, as you say, the probability. And there are two definitions on the screen. One is more likely than not, and the other is disproportionately disproportionately likely as compared to other defendants. And that particular one, number 2, specifically applies to statistics, correct?
They both have a statistical foundation. More likely than not, it's a statistical consideration. That means at least 51%.
Objection, Your Honor, non-responsive.
Yes, sir.
Now, in this slide, which is slide 26 for the record, and I don't know. I have not identified it. Is it in here? I don't have it. Oh, it's not. Oh, it's not. So for slide 26, are you aware that in Texas, when the jury is answering the future danger special issue question, the circumstances of the capital crime can be enough to answer?
Well, no, ma'am. The jury does not answer a future dangerousness question. They answer a special issue.
Are you aware that in Texas, when the jury is answering the special issue, the circumstances of the capital crime can be enough to answer that? Yes or no?
I would defer that to the court. Well, I hesitate to get into a discussion about which sentencing factor.
One second.
The cir-
One second. You're okay.
Well, Judge, the question was asked, the witness said he would defer to the court, which is proper, and then the state just repeated their question like a second time. It's asked and answered. It's irrelevant. Law comes from the court.
Let's move on to the next question. If you already answered.
You're aware the factors that the jury can look at when answering special issue number 1.
Can you approach? Jury, at the end of this trial, as what happened during the first phase of the trial, the court is going to give you the charge and instructions, and is going to give you what the law is on this phase of the trial, and what are the things that you can take into account, and you will, in fact, deliberate in accordance with those instructions. So as we move forward, please remember that.
Yes, Your Honor. Allow me
To
to,
the jury.
allow me to find my notes.
Yeah, sure, go ahead, take it.
Dr. Cunningham, on this slide, you stated on here that the severity of the offense is not a good predictor of prison adjustment. Is that correct?
Correct.
And you do realize that this is a fact that's in evidence that may be considered by the jury.
What's considered by the jury
Yes.
and for what purpose is, again, above my pay grade. I can say the
Miss-
severity of the offense
one question,
is
please.
not scientifically related
Give me a
to
second,
whether he
please.
commits violence in prison. Sorry.
Second, please. I think I already ruled on that, and I asked you to modify your question. In other words, do you want me to clarify?
Yes.
Okay, come forward, please.
So your statistical assessment or your assessment does not take into consideration the
I
severity.
can't hear you.
I'm sorry, I'm muted.
Dr. Cunningham,
Somebody did. Thank you.
Dr. Cunningham,
Yes.
can you hear me now?
I can, thank you.
Thank you. So your assessment, your statistical assessment or your assessment does not take into consideration the severity of the offense, correct?
No, ma'am. It simply finds the severity of the offense not to be predictive of prison violence. We did examine it. I do take it into account.
And it shows that, but my question is, in your assessment, you found the severity of the offense not to be a good predictor of prison adjustment, correct?
Not one that elevates the risk, some evidence that it lowers the risk.
So the answer is yes or no?
I guess the answer is I can't answer yes or no without some clarification.
On slide 28, when we discussed, and I believe your testimony yesterday, when you were discussing intensive clinical evaluation, you mentioned that this is the area where you compare whether it was impulsive versus premeditated. Is that correct?
No, ma'am. I described that almost all offenders in prison are impulsive. And so if that were a characteristic identified about a defendant, that would not, the rate of that is so pervasive in prison that that feature doesn't then tell us the rare inmate who commits serious violence in prison.
So the fact that it may be that this murder was premeditated, would that be a characteristic that would influence your assessment?
It's a factor that we have looked at and found not to be predictive of serious prison violence.
And so in your assessment, premeditation or forethought is not predictive.
Of serious prison violence, no, ma'am, it's not.
Now on slide 31, this was when you were discussing the dynamics between the inmate and other inmates and the vigilant staff and the restrictive context.
That's correct. It is so effective in limiting severe violence, even among a group that you might have thought would be violent or were violent in the community.
Now, this, your assessment or your evaluation, it didn't take into consideration things such as security lapses?
Well, yes, ma'am, it takes that into consideration. The rates of violence in Texas prison are extraordinarily low in spite of the human frailties of security
Dr.
lapses and
Cunningham.
mistakes and that kind of thing. It does take it into consideration.
Did it take into consideration the possibility of inadequate strip searches?
Sure, all of that's incorporated in that. So we can assume that mistakes are being made in Texas prisons every day by staff of some sort. In spite of that, they're so good at the rest of it and so much of the time that it limits the extent of severe violence.
Did your assessment also take into consideration poorly applied restraints?
Certainly.
And
I think same answer.
okay, and did it take into consideration staffing shortages?
Yes.
Or,
But this data is from 2022 when TDCJ was experiencing staffing shortages. So yes, it took it into consideration.
and did it also take into consideration officers becoming complacent?
Yes.
Now, and you also said yesterday that nothing is 100% preventive, correct? The security measures. Yes or
The
no?
security measures are not perfect. I don't think I said it's 100% preventive or not. You mischaracterized it. I may have said something like that, but not what you described.
And so, are you, Dr. Cunningham, I'm going to ask you some questions and ask you if you are familiar with this, and I'd like a yes or no answer. Are prison escapes a reality of prison? Yes or no?
Yes, extraordinarily rarely from secure perimeter facilities.
Objection, Your Honor, to non-responsive.
It's impossible to answer.
In other words, inmates escape. It's because of security measures failed. Is that a yes or a no?
Yes.
So as an expert evaluating prisoners and risks, are you familiar with the following escapes? The following escapes, inmate escapes.
Time, and we'll get right back. Thank you. So to finish this conversation, the defendant's in the courtroom and with counsel. To be able to finish this conversation outside the presence of the jury, I find nothing, and if y'all can locate something, this is the time to do it, or this would have been the time to do it, that allows you to bring in the individual acts of violence and the details of who's murdered or killed or slashed inside of the prison. I find nothing that would allow, honestly, I find nothing that would allow the details of individual killings or individual acts of violence by other inmates or other prisoners to be relevant to because otherwise you could bring in every single one of them that have occurred during. What's to stop you from doing that? In other words, from bringing in every single act of violence that occurred in 2022, every single act of violence that occurred in 2023 to 21, every single act of violence that occurred in 2020, and so on and so forth down the line. What's to keep you from doing that? Just time?
No, Your Honor. The purpose of us bringing
My direct question was, what's to keep you from doing that?
for bringing in the individual.
Yeah,
units?
individual, all the details of the individual act of violence of each and every serious act of violence in prison. Like somebody got killed, somebody got slashed, somebody inside the prison system. Because we're talking about acts of violence that could occur. The probability that the defendant would commit act of violence that would be a continuing threat to society, right? And the society we're talking about is any society, right? Prison society or even outside society when if somebody were to escape. So you're saying I want to bring in five. I want to ask the witness five individual questions about five individual escapes and what occurred and what type of violence occurred in each one of those five individual escapes. And even if he doesn't know about the individual escapes, I want to be able to tell him what the facts were and whether or not he knows about it. And I'm saying, well, what's to keep you from don't use those five individual escapes because those are just individual cases that have nothing to do with the defendant. Use the 200 or the 300 acts of violence that occurred in 2022 and lay them out, each one of them in front of the jury. And how is that any different than the acts of violence that occurred as a result, than the third party acts of violence that occurred as a result of escapes? That's what I'm saying. What's the difference?
The difference, Judge, is the narrow purpose for this was to respond to the representation that the escapes were, I don't remember, the very small percentage.
But you don't have to tell them give me a second to be able to respond to the fact that the witness said escapes are a small fraction or percentage or whatever he used of the possibility of what a individual that is in prison, similarly situated, whether it be what is it, three? What is it? I'm not sure what the classification is, but whatever that three was, would be compared to now. I want to tell you the individual tragedies of what occurred as a result of those escapes. Have nothing to do with what the probability of that actually happening, the escape actually happening.
And we have modified our question, Judge. We are not going to go into all of them, but we do have a statistic that we will ask, which is from
now statistic with regard to what happens, whether or not you're saying the statistic of what occurs when that small number of cases that in which people do escape, are there acts of violence that occurred in those situations? I think in general, like that, is different than what you were planning to do before.
The only exception is we will refer to the one individual that was discussed yesterday.
But he was only for purposes of a percentage. He wasn't talking about, he only used that particular case. First of all, that case had already been brought up during the first witness that the state had. But I doubt, similarly to me, by the way, that the jury knew the name of the case and associated with the first witnesses, the state's first witness mentioning of the case, of a case in general, without naming the case. But anyway, the use of that by the juror, by the witness, was to illustrate in fact, he could have said no name and just said it was a small percentage or a small fraction of, it could have been anything. It could have been, in other words, I'm not sure that there's any connection between a small fraction or whatever he used. And remind me if I'm missing something of the cases that are out there, because I think he's using the word predictive and probabilities and stuff like that.
Just on that case, I think the witness's testimony, the way he phrased his response was to minimize the escape of Gonzalo.
Well, instead of giving me the conclusions, tell me what he said. Because you're giving me the conclusions of what you think he said, or your interpretation of it.
Yeah, and
Well, my recollection, his testimony was that it was one escape. It's statistically, statistically it rarely happens.
And you believe that's incorrect?
And well, I think that escapes do happen more than what he's represented. That's what
Right. And so you're basically saying his data is wrong.
yes, I disagree with all his data.
But you have no one here to.
No, but again, it's an interpretation of his data based on the way he's plugged in his formulas. But we're on
But on the escapes portion, he does have a data on escapes portion. So you in other words, you could ask him about his data and basically call to question his data, no question. But I mean that you can always do through questioning.
Okay.
But it's hard, I guess, to do when you have nothing to controvert that. I guess is what I'm saying. But
what I'm asking for is,
or to even argue against it, I guess is what I'm saying.
so what he did, he talked about statistics. He talked about examples involving analogies involving airplanes, involving teenage people who are driving vehicles, that it's used to cause fear in juries, that type of information, like the Gonzalez Lopez.
No, the airplane portion was an analogy, not to instill fear in juries. It was to instill fear in
fear in people not to get on the plane.
right.
And making that analogy to the case of.
I don't-
And what we talked about with Mr. Boggs right now was that we weren't going to give the names of the other escapees. We're going to give
Just the details of the crimes.
Some and statistics. I'll go over the question.
Judge, I'm a little confounded because I believe it was the state's first witness who said that in that time period that there had been one escape of a G3 inmate. So for the state to now say that our witness is somehow distorting statistics seems confusing to me when it was actually
Well, they won't be.
state's
The state will
witness
not
who
be
said
able
that.
to argue that to the jury because there's no evidence to that effect. So I don't think that's.
Can I respond to
Yeah.
that? Now, from the slides that we've seen, Dr. Cunningham's slides go back to 1975,
Oh, there's so many.
but his statistics go back to 1975.
Well, you can't really say. In other words, each slide is individual. So right.
Yes,
So there's slides at 75. Some are 2022. Some are in the 1980s. Some in the 1990s. Some
But the date that we saw that his slides go back to.
Well, you're saying some of his oldest slides, some of his oldest data is as old as 1970.
Some of his oldest data is
Yeah.
up to 1975.
Okay.
And we believe that makes everything from 75 to now relevant with respect to escapes and asking him if he's familiar with the
escapes that occurred in 75. How many escapes occurred in
since
75?
then, since then. And if we strategically want to ask him about the 1, 2, or 3 escapes,
But it's okay to ask him about whether there's been escapes since 1975. That's fine. The only thing he's going to do, I'm going to tell you, he's going to come back and tell you, now we need to give you a proper statistic with regard to that. I need to now give you the number of inmates that have been in prison every year since then, and then divide that up into a number to give you. I mean, and then that's going to,
and that's fine.
I guess that's what I'm saying, because you that's what's going to happen. And so, are you basically saying there has been? I don't think he said there was only one escape. I think there's been three or four escapes.
Well, he made reference to in 2022 that one escape.
Yeah, but there's been in the data I've seen, there's been more than one escape.
Or an escape attempt. But I do believe we have the latitude on cross-examination if he's an expert to be able to test his knowledge and expertise as to the issue, the narrow issue of escapes.
But like, what do you want to ask him on escape? Whether there's been escapes?
Whether he knows the number of attempted escapes at least since 2005, because that's the information we have.
Okay, well, assuming he says no, then what?
And he answers no.
That's it?
Yeah, then he answers no.
Your Honor, may I just address one point, which is Your Honor asked whether there was any authority that permitted them to get into this.
Or not?
Or not. And I want to give the court a recent case, a death penalty case. It's Calvert versus State. It's an unpublished opinion of the Court of Criminal Appeals. The citation is 2019 Westlaw 505-7268. It's at star 5859 because it's an unpublished opinion. In that case, the state presented testimony from a TDCJ guard about an incident in which another inmate, not the defendant, stabbed him in the eye and about the injuries that he sustained. And the defendant objected on relevance and prejudice versus probative, Rule 401 and 403 grounds, and the Court of Criminal Appeals found that it was, in fact, more prejudicial than probative because there was no evidence that it was unrelated to this defendant. There's no evidence that this defendant had stabbed or attacked anybody, and it was therefore not admissible. And so I think
In that case.
and I think every instance in which the prosecution tries to discuss facts that are or cases that are unrelated to this case is inviting more error. And I think the fact that they've already elicited it from Officer Fitzpatrick, I believe, is already problematic and forced us into the position of having to show why that extremely aberrational incident involving an inmate with a completely different history and record than our client committed that offense. And it's really forced us into that
All right.
position. We can't do
Well,
this.
it's not going to, those details I already said we're not going to come in.
Yes.
Mr. Zondo, you'd like to address the court?
Yes, Your
All
Honor.
right.
It's two things, very briefly. One, we're already beyond that point. And second, to correct Mr. Schoenman, it was the defense who elicited that one prison escape and how many individuals died. So that's
I don't think that's my memory of that. How many individuals died came in through Mr. Ellis?
that
Through
one
Mr.
person
Ellis?
came out. That one
I'm
person had escaped. So
Yes, sir, but
ultimately-
that's not what the record is with regard to who asked the question with regard to how many people had died. The
Yes.
defense did not ask that question.
But they had opened the door.
I know, but you make it sound like
Okay,
the defense.
apologies, Your Honor.
Yeah.
I am correcting for the record that they had opened up the escapee And then once that door was open, you went.
We'll,
through how
we'll
many
let somebody else. That's already water under the bridge for
So-
purposes of. Give me a second. Finish my thought. For purposes of what we're doing here, what we don't want to do. Whatever happened there already happened. Jury already heard it. I can't undo it. Whatever somebody else is going to measure us with regard to whether that was proper or not at some point. I don't want to add anything more to that. Go ahead.
Correct. So now the state has seen statistics that in the year of 2020 or 2021, I believe, one of those 2 years, that there were nationwide from federal and state prisons, roughly 2,000 escapes.
Or attempted.
Well, that's just the actual escapes. That's what the statistics are showing, and that comes from a government website. Now, with that in mind, I think because he made it seem like escapes are nationwide or a rare thing that happened, and then he mentioned the one case that happened in Texas and said that people loved it, and he implied it, and he pretty much said it with the plain analogy that the state is essentially trying to bring this up to fearmonger the jury into giving a death.
Yeah, I know you guys are making that, but I really, unless I just missed it, I didn't really get it like that. But go ahead.
So with that in mind, the state would simply like to ask, are you aware that in the year of X, and we can get the right year, that there were 2,000 escapes from federal and state prisons nationwide? And then he can say yes or no, and we can confirm him with that.
I don't have a problem with those. I'm not. We were not here to discuss that type of stuff. Data, numbers, that stuff is all free game. He's already talked about that. So yes, it's free game. I'm talking about the details.
So, yeah, but
And
we had already cleared up that issue. We're not.
yeah, but that didn't happen before I was the break. That happened after the break.
Okay, and we're gonna announce when you came out
All right.
that we would not discuss the details, specific details of those escapes. But if the witness is familiar with the escape, for example, in 2000, where 7 inmates broke out of the commune, yes or no? Do you know that? That's not discussing any.
Whether he's familiar with an escape that occurred in 2000, and how are you gonna?
And if he's familiar with an escape that occurred in 1998, from the Ellis unit, of course, being an expert in prisons here in Texas, if he's familiar with the escape in 2010 from the Briscoe unit, specific, just questions, not names, but if he's familiar with those escapes, those statistics, without getting into any detail.
All right. Anything?
Judge, this was the subject of pretrial litigation where the court ruled specifically that the state was prohibited from going into, for instance, the Texas 7, which the state is now saying that they want to ask the witness about. And furthermore, Your Honor, I want to correct the record as stated by Mr. Elizondo, who said, I elicited the testimony about the single escape attempt. It was Mr. Alanese who did it on his direct examination with Mr. Fitzpatrick. The only question I asked Mr. Fitzpatrick about the single escape was the statistical rarity of it. And then Mr. Alanese on a redirect indicated the scope of the number of deaths. from
Okay.
that statistical. So
That's been cleared, and I re-cleared. Okay. So you want to put a name and a number to,
I want to put a year and a number of I wanted to put. Well, with Gonzalo Lopez, I was going to ask some of the facts.
we're not going to go into any of the facts,
Okay.
period, on those. Just that there were
Now,
escapes.
we could ask him the age of Gonzalo Lopez because that's something he's testified to. as
You can
well.
ask him the age of the escapees,
Correct.
but not of Gonzalo Lopez.
Well, he was an escapee, Gonzalo Lopez.
I know, but not of the name Gonzalo Lopez, just the escapees of that day.
Okay, so if I could just ask him.
Just replace the name Gonzalo Lopez with the age.
Okay. Are you familiar with the age of the escapee in 2022 that he was 46 years old?
I thought you said whether you're going to ask him whether he's familiar with the age. If he says no, then you're not familiar with the age.
Well, I can ask him if he's aware he was 46 years old because he's coming.
But how do we know that that's a fact?
Well, if he's done his studies, he'd know that because he said, according to age, between 20, that the older you get, the less likely. He said under 35. He said once you get past 35, there's a less likely.
The predictive is less and less, right?
Exactly, and I have a case here of a 46-year-old who escaped and killed 5 people.
Well, you're not going to say that.
No, but it's to my point that Lopez was 46 years old, so that goes outside the spectrum.
You can ask him, do you know how old? If he said no, would it surprise you if he said it was 46 years old? I think that was fine.
That's all.
well, the question assumes a fact, not an evidence, is what I'd say. And if the state wants to introduce that, they have a rebuttal case in which they can try to elicit that. This has been the subject of pretrial litigation.
I understand that, but I think it'll just.
If he knows his age or not, Your Honor.
Right, but you're not just asking if he knows his age, you're asking if he knows his age and yeah, I mean, And I think a follow-up question to that would be the age. I'll allow that.
Thank you.
And you can object at that time as well. Okay, so no details. We're good to go.
Thank you.
Let's wait the jury. Let me see if the jury's ready.
All right.
Thank you all. Please have a seat. We'll continue with the examination. You may proceed, Ms. Jackman, when ready. Dr. Cunningham is, I believe, ready.
Thank you, Your Honor.
Dr. Cunningham, I'm going to direct your attention to slide number 48. Are you able to see that?
I can, thank you.
Now, on this side, I believe the purpose of this side was to highlight that he was employed he was in the military and was employed by Border Patrol, and that was a positive factor, thereby mitigating his risk of prison violence, serious violence, correct?
It's a little more complex than that. His having an extended and continuous tenure of employment across his adulthood is a factor that reduces the likelihood of prison violence and increases the likelihood that he will engage himself industriously in prison.
And so therefore, he is less likely to be involved in prison misconduct and violence because of this factor.
That's correct.
And are you aware that he used his job at the Border Patrol to create the opportunity to commit these murders?
I am.
And that he used the equipment provided pursuant to this job to commit these murders?
That's been asked and answered on the previous questions.
Are you aware that he also tried to avoid detection using his authority as a supervisory Border Patrol agent?
Yes and no, as I understand how this unfolded. His authority actually had nothing to do with the local police, who promptly zeroed in on him and brought him in.
Thank you. Now, the fact that he was in the military, you consider that as a positive factor, correct?
I did. And not just in the military, but then had a long tenure in the reserves as well.
Now I'm going to direct your attention to 51. Well, it actually starts on 50. And you identified continued contact with community members as a positive or a mitigating circumstance where it reduces the likelihood of Ronald Burgos' opportunity or committing acts of violence in prison, correct?
No, ma'am. I don't consider this to be a mitigating circumstance, as that's understood in capital sentencing. This is a factor that's associated modestly with a lower likelihood of misconduct and violence in prison.
Now, you mentioned that he speaks to his spouse, his father, paternal uncle, paternal grandmother, paternal step-grandfather, mother, and paternal aunt. Did you have the complete records of the jail calls?
I have no way of knowing whether the records that I received were complete. I did receive visitation logs, and as I recall, telephone logs as well.
And in the visitation logs, you mentioned that visitation, periodic visitation is a factor. And I believe it's on slide 52 where you say disciplinary infractions were infrequent, whether visited or not. Is that correct?
That's correct. The overall base rate was low, independent of whether you were visited. If
And
you were not visited, those inmates had higher rates, significantly higher rates of misconduct, but it was very low for all the groups.
and any visitation reduced the likelihood of misconduct. Is that correct?
That's correct.
And you represented yesterday that the spouse had periodically visited with Mr. Ronald Anthony Burgos.
She is among those who visited periodically. I think her visits have been infrequent, but they have occurred.
Would it surprise you to know that the last visitation was approximately 4 years ago to the day?
Judge,
It would not.
Says a fact, not evidence.
Overruled.
Now, Dr. Cunningham, did you receive any call logs regarding Sahara Camp Drone?
I don't recall that name.
I'm going to refer your attention to slide number 38. And the purpose of this slide was to show that as the inmates got older, the chances of their infractions would reduce. Is that correct?
Both older at the time they get to prison and older as they age in prison.
Do you recall yesterday discussing an escapee in 2022?
I do.
Do you realize that he was 46 years old?
I do. With a criminal record that went back 26 years.
Objection, Your Honor, non-responsive.
It actually is
Sustained.
very responsive.
You could what is it, direct on that.
Now, Dr. Cunningham, you do, because you have statistics on prison, you also have statistics on escapes.
I'm sorry, you broke up. I've lost the last half of your question.
Do you have statistics on escapes from prisons?
I'm sorry, I can't hear you.
You know what, I think the mic, something, is that mic connected or not connected?
Yes.
No, that mic, the round mic.
Yeah, it's on your honor.
So for some reason, it's saying it's not. Okay, but I said you could hear well. Is that correct, Ryan? Okay, try it again.
Dr. Cunningham?
Oh, she can. Okay, so it's let me do this.
The battery's empty.
What about, can you hear me? No?
Mr. Cunningham just has to cross over.
Okay. I'm listening. I guess you can hear me. We had problems earlier, that's why we want to come up.
Might be the battery, Your Honor. The battery says it's empty.
Yeah, that's why, was it connected?
It's connected.
Until a minute ago, before this happened, was it connected?
Yes, Your Honor.
So it doesn't require a battery to be connected. Can you bring it back over here and let me see, I think I need to, sorry. I'm gonna do, somebody call Frank. we're on a Zoom witness, we need these microphones. I never had these phones, ever, except for today. But they changed my connection.
And we are back to the wall of ham, and I have no idea how long this break is going to be because they didn't come and tell us. They were kind of doing their sidebar stuff. So I guess it's a plan to do things on the fly. Let's see. What I've got that's short. Let's take a look. Let's see. Oh, yeah, there's a guy apparently confessed to a friend about John Benet Ramsey at the time of the murder before the newspaper came out telling the details. And so the guy reported the tip to the police at the time, and he didn't hear back from them. So 3 months later, he called in again and still never heard back from them. And so this came out. Let me see. Let's find the piece on that. Because that's huge news. This guy is in prison for another child offense. He was living in Boulder at the time, was getting his mail 13 doors from the Ramsey address. So he, and he is supposed to have confessed after he went to jail for this other offense. So multiple confessions, proximity, and so he, of all the different cases or people I've heard, this is the first one that sounds like a compelling suspect. So let me get this queued up. Let's see. Okay, just about got it here. Okay. Let's see.
JonBenet Ramsey was found dead, strangled in the basement of that home. Wasn't kidnapped. This case still never solved. No one's been held responsible since 1996, but some huge developments tonight we want to talk about. Let's bring in our special guest joining us in New York, senior reporter for the U.S. Sun, Luke Kenton is with us. Luke, great to see you. Thanks so much. Read your article. Wow. Let's talk about this development. It's a man named Gary Oliva. Gary Oliva, tell us what you found out about him, what his link is to JonBenet Ramsey.
So Gary Oliva, first and foremost, is not a good guy. The story involving Gary kind of begins on the 27th of December 1996, when he was reported to Boulder police because basically the night before he'd called an old high school friend back in California who he said through tears and could barely catch his breath, "I've just hurt a little girl." So this was on the night that JonBenet's body was, a few hours after JonBenet's body was found on December 26th. He was crying that he'd hurt a little girl in Boulder and he hung up the phone. Now his friend that was on the other end of the phone didn't know really what to make of that call, was obviously concerned, but couldn't get any information out of him. It wasn't until the next day that he went on the front porch, picked up the newspaper, and saw the news that a 6-year-old girl had been killed in Boulder, Colorado. He immediately calls the Boulder Police Department, reports the call from the day before, and then 3 months pass. He doesn't hear anything, and he calls the tip line again, reports it to Boulder Police, doesn't hear anything again. Fast forward 19 years later, Gary Oliva is in prison for child pornography offenses and confesses in a series of letters to the same person that he called that night, claiming to have killed JonBenet by accident.
This is unbelievable. I mean, this is, did police ever talk to this man in California? I mean, he is claiming to have gotten a call before this story is even in the news from this guy.
Yeah, so hours before it, made headlines across the country, he said, "I've hurt a little girl," and he's in Boulder. And bearing in mind at the time, this guy was was associated with a property about 13 houses away. He was getting his mail from a church 13 houses away from the Ramsey family. And the tip, like I said, wasn't followed up upon immediately by Boulder police. At the time, they were zeroing on either Patsy or John Ramsey being responsible for JonBenet's death. It wasn't actually until 4 years later when he was arrested on the campus of the University of Colorado in Boulder with pictures of JonBenet in his bag, a poem that he'd written to JonBenet called Ode to JonBenet, and he was also found with a stun gun. And that was kind of a crucial development for investigators because over the course of their investigation, after the first few months, they kind of theorized that perhaps that she was subdued with the stun gun prior to her death. So that's when police started looking at Gary, which was 4 years later.
a mic over there for you. Let me get you over here.
Linked.
Can you hear us? Oh, no, you can't hear us.
Yes, I can hear Your Honor.
Okay, thank you.
Mark Cunningham.
All right, thank you. All right. Okay. Go ahead. Please don't be try not to be distracted with us over here.
Dr. Cunningham, you can hear me now? Emily? Can you hear me now, Dr. Cunningham?
You were breaking up. I only caught a couple of words.
No. Is that better? Is it cutting off?
Still breaking up.
Can you hear me?
Yes, Your Honor.
Do you hear him coming out over there on the screen?
Yes.
Just the mic over there. Say something over there again, please.
To Dr. Cunningham, is it coming through clearly?
No.
How good is your spelling?
You are an expert or have collected information regarding the prison system, correct?
I'm sorry you broke up.
Again. Now, can you get on your mic? Maybe that'll help. Because you may have to be able to talk to this speaker, the microphone.
Does it come through clearly now?
Yes, it does. Thank you.
Now, we were discussing your expertise on the information that you collect from prison systems.
Yes.
Do you collect information regarding the escapes of inmates from TDCJ?
Yes, I have information on escapes from TDCJ.
Do they go back as far back as 2005?
Yes.
So then you are aware that since 2005, there have been 48 inmates within TDCJ who have attempted to escape, correct?
Well, that's yes and no. TDCJ back in 2005 was defining an escape as any unauthorized departure from custody. And that included a failure to return to custody following an authorized leave, an unauthorized departure from a work assignment, or unauthorized departures from intermediate sanctioned
How good is your
facilities.
spelling?
And so this included walkaways. That isn't over 40 individuals who have escaped from secure perimeter facilities. At least not if you're basing this on the Emergency Action Center data that TCJ has been promulgating monthly since I started getting it maybe 25 years ago.
And in all these occasions, they violated the rules, correct?
Well, yes, even if you're in
Thank you. Thank you.
community work release center and you walk away, that's a violation of the rules. It's just not an
Mr.
escape
Cunningham- Dr.
from a secure
Cunningham?
perimeter facility.
Thank you. You answered my question. Now, Dr. Cunningham, how many times have you testified for the defense?
I never testify for anyone. I may be called by one party or the other, but I never testify for them.
So how many times have you been called by the defense?
I can't give you a precise number. I'm confident that it's hundreds of times, 300, 400, 500 times.
And you've been asked to testify in future dangerous evaluations for the special issues?
No, ma'am, I never do a future dangerousness evaluation. I do a violence risk assessment for prison in response to the special issue if that's requested.
Okay, and so in your assessment for the violent risk assessment, how many times have you testified that a defendant posed a future danger?
I never testify about whether someone does or does not pose a future danger.
How many times have you testified that a defendant is likely to commit serious violence in TDCJ?
I can't give you a precise number. On a few occasions, if in the general prison population, an offender, because of those risk characteristics, could pose a disproportionate risk. That said, there is always a level of custody that will
Cunningham?
incapacitate any offender.
Dr. Cunningham, I'm referring to death penalty cases only. And in death penalty cases, when you've been asked to give your opinion as to whether they are likely or unlikely to commit serious violence in TDCJ, how many times have you testified, after being called by the defense, have you testified that a defendant is likely to commit serious violence in TDCJ?
So the defense has never called me when my finding was this defendant had a disproportionate risk. They've not then called me to testify.
Can you recall how many times you have found that he was likely to that a defendant was likely to commit serious violence in TDCJ so that they did not call you?
I can't give you a precise number. Often that happened in the first phone call. They would inquire about retaining me. I would seek some basic information regarding the defendant and risk factors, would then describe that this offender had an increased likelihood, might not be more likely than not, might be, but had an elevated risk. They said, thanks, I think we won't proceed to retain you. So there was simply there was never a retention that occurred.
So you don't
got
have
the information.
So you don't have a statistic on that, correct?
I don't have a precise number, no.
Thank you. No further questions, John.
Mr. Boggs, any redirect?
Yes, sir.
Can I'm going to ask you also to speak into the mic so that they can hear you, because we only have one microphone that we're using. And it's going to be this one over here, unfortunately. It can't reach over there because it's got to be connected.
Judge, should my, I don't need it to be. I haven't used astringent today, but should my video be on?
So you should be able to turn it on, but
It says I cannot.
and you can click on the screen now. Yeah, you can do it on your own, or I can ask you to do it. Do you want this to be taken down? Because that's theirs.
So, Judge, I'd ask that Dr. Cunningham be allowed to present. I may ask him to present.
Okay, so I'll
certain
take theirs
slides.
down, which I already have, and then Dr. Cunningham, at Mr. Boggs' request, you can put on your slide upon his request. Thank you.
Yes, sir.
Dr. Cunningham, thank you for your patience. I believe that the state showed you slide 35 and asked you about individualized assessments and on the scale between most scientific and least scientific. Do you recall that?
I do. Would you like for me to display the slide?
Yes, sir.
Just a moment.
Yes, sir.
Yes, sir. Let me try this again.
So I have, that appears to be slide 36. I believe the original slide that they asked you to display was, yes, sir, slide 35.
I'm sorry. Let me see if I can turn on the slideshow.
Now, Doctor, you were portions of your previous texts. Could you explain those texts in relation to this slide, which is of clinical evaluation in the middle after actuarial and past patterns of behavior?
Certainly. So the text is oriented toward describing a capital sentencing evaluation that may be directed toward one or two different issues. And one arena of focus of a capital sentencing evaluation is adverse factors that are in the defendant's background, family dysfunctions that may even go back generations that were formative. And that involves a very intensive evaluation, when done properly, a very intensive evaluation of nearly everything you can think of that might go wrong in development that would lead someone to committing a capital offense. And that might be in from one generation to the next, family dysfunction, it could be neurodevelopmental issues, could be family and parenting issues, could be corruptive community exposures, could be disturbed trajectory of getting off track and that then increasing over time.
Okay.
And so as we think about an interview, if that's the sort of focus, if it's on this adverse developmental mitigation side of the evaluation, then an interview of the defendant may provide history that you can't get from anyone else, may provide a history, for example, of being sexually abused that nobody else knows, or provide specific descriptions of physical abuse that only the child is aware of because he experienced it. Largely, though, whatever history you get from a capital defendant, you're going to want to corroborate and seek that information independently from other people, because the capital defendant obviously has a dog in the fight. but there are some things that maybe only the defendant can tell you about. Now, and also if part of the mitigation is that there was a severe psychological disorder that was occurring at the time of the offense, then it may be necessary to psychologically evaluate the defendant in order to illuminate that serious disorder, like he's schizophrenic or has bipolar disorder or that kind of thing. At the same time, it's possible to do a capital sentencing evaluation even of those adverse developmental factors by basing it on extensive interviews of other people and on records, because it's largely a historical evaluation. And other people can give you that history and may give you it to you better than just the defendant. But an interview of the defendant, if you don't interview the defendant, there may well be some adversities that you don't discover. That's the problem with it. Now, when you come over to a violence risk assessment, an interview of a defendant is, I'll still inquire about interviewing the defendant, but it's a very small part of the evaluation, because the factors that are predictive of violence in prison are not about this individual's personality or psychological disorders they may have, but instead are rooted in factors that you can get other places, in other records and by speaking to other people. And so as I interview a defendant for an evaluation of the risk assessment for prison, that interview might only last an hour and would involve asking the defendant about how he's housed in jail, with what contact with staff or inmates, his take on any disciplinary infractions that have occurred, his educational level, his employment history, how he's occupying himself in jail. It's a very limited fund of information, and who's coming to visit him and how often they speak, or what phone contact he has. It's information that I can probably get from the records, but speaking to the defendant kind of gives me some direction with that. But it is a very, very small part of a violence risk assessment for prison, and kind of near optional.
So, doctor, if I understand you correctly, you're saying that you can do an individualized risk assessment without direct contact with the accused. Is that correct?
That's correct, because that information, those correlates are available from other places. In this instance, I desired, if I'm not going to actually interview him, let me at least see him interacting so that I've laid eyes on him at least and have a general sense of his, interpersonal demeanor and ability to express himself and that kind of thing.
And, Doctor, on Special Issue 1, are you aware of whether the state holds the burden or the defense?
It's my understanding the state has the burden to prove beyond a reasonable doubt that there is a probability the defendant would commit criminal acts of violence that would constitute a continuing threat to society.
Sustain. Move on, please. The court is the one that's going to be given those charges to the jury.
You were asked by a prosecutor whether or not your models.
I'm sorry, you're breaking up now.
Yeah, you need to get close to it.
Doctor, you were asked by the prosecutor whether or not your models took into account the severity of offense. Do you recall that?
I'm sorry, I still couldn't hear you.
Doctor, you were asked by the prosecutor whether your models took into account the severity of the offense. Do you recall that?
Yes.
And do your models take into account the severity of offense?
They do. Many of the studies that I described involve the follow-up of capital offenders in prison, groups of murderers, groups of murderers who had killed more than one person or were in close custody. A lot of my data is organized in examining how murderers are behaving in prison. It's simply that the severity of the offense doesn't result in somebody being more likely to commit violence in prison, and broadly is associated with a somewhat less likelihood But yeah, lots of the studies that I described were specific to murderers.
Now, Doctor, you were asked on cross-examination about escapes, and specifically an escape that occurred in 2022, and you were asked about the age of that escapee. You recall that?
I do.
And could you tell us about the criminal record of that escapee in 2022?
Objection. Relevance, and that was discussed.
Approach, please.
Meow. 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 Hi. Hi. Meow.
Asked on cross-examination about the age of the escapee in 2022, correct?
Yes.
And that escapee, did he share a criminal record in his past similar to Mr. Ronald Burgos-Aviles?
No.
Did he have an extensive criminal history?
Objection, Honor.
He did, extending back 28 years before 2022, back to 1994.
And how many how often do escapes happen within the Texas Department of Corrections?
From a secure perimeter facility, very, very rarely. And in fact, even in general, rarely. I can give you some but because it includes these folks that may walk away from a community supervision or that kind of thing, as you include those kind of cases, I think it's 2 to 4 times a year that happens based on the Emergency Action Center data of the last, since 2013-14. And I've got data that goes all the way back to 2005 and before. But even as you allow for those walkaways from community supervision, it's only 3-4 annually, and I can give it to you specifically by year, but I'd have to quit sharing my screen and maybe share that Emergency Action Center report.
So, Doctor, you were asked on cross-examination about whether or not you're being paid for being called as a witness. You recall that?
Yes, and I responded that I'm paid for my time by the hour, not for my appearance.
And a part of the scientific method is the ability to test results, isn't it, Doctor?
It is.
Okay. Has your data and the studies that you've conducted ever been tested to see if your predictions were accurate?
Well, the studies are all tested in terms of having undergone peer review, which is a critical screen that all scientific research that's published undergoes. But if you're inquiring about, have I ever done follow-up on the cases that I was involved in providing capital risk-related assessments for prison violence, I did conduct such a study. To my knowledge, I'm the only forensic psychologist who has ever done so.
And do you have slides that are available to illustrate these studies?
I do.
Okay. Would it help this jury to see those slides?
It could. I can simply describe them, but I can also pull up a file that has those 2 slides in it.
Approach, please.
I'm for the record, I'm holding Defendant's Exhibit 13. And Dr. Cunningham, can you hear me?
I can, thank you.
Now, I'm holding Defendant's Exhibit 13, which is a copy of your CV. And we didn't go over these yesterday, and I don't want to go over too many, but you've received a number of awards. Is that correct?
I have.
So for instance, the American Psychological Association Award for Distinguished Contributions to Research and Public Policy. You received that award?
That's correct. That's an annual award that's given to one psychologist annually for distinguished empirical, that's research-based, or theoretical contributions to research and public policy. That's research having significance before legislative bodies or the courts or the public at large. And so it's the contribution to research and public policy, either through a single extraordinary achievement or a lifetime of work.
And sir, you've been testifying about prisons these past 2 days.
That's correct. That's my most significant empirical and theoretical contribution to science and to public policy, is informing considerations of violence risk assessment for prison, and more particularly in capital cases.
And a matter of fact, you've received an award from the American Correctional Association, the Peter J. Leyens Research Award.
Legends Award. Yeah, that's an annual award that's given by the American Correctional Association to one or two correctional researchers each year. It's the highest honor that they bestow. And it's for distinguished empirical or for significant research for the correctional community and development of new information that adds to this profession and improves the profession of corrections.
And what is the American Correctional Association, briefly, sir?
That's the professional association of prison staff members, wardens, researchers. This is their professional association, correctional professionals, both state and federal.
And sir, you also received an award from the American Academy of Forensic Psychology.
That's correct. I was recognized with that just this last November.
And
that was that was their Distinguished Contribution Award. That's an annual award that's given to one psychologist. This is the highest honor that can be bestowed by the American Academy of Forensic Psychology. The Academy is the scholarly association of board-certified forensic psychologists. So this is this group of 380 most preeminent forensic psychologists in the United States. And this recognizes outstanding contributions to the science and practice of forensic psychology.
And I believe we discussed yesterday that you are a naval veteran.
I am.
And did you receive the Navy Commendation Medal?
I did. That was toward the end of my tenure at the Sub-Base Medical Center in Groton, New London, Connecticut. And I think I may have mentioned yesterday, it's a very unusual decoration to be given to a junior officer at his first assignment.
And sir, you've testified that you're board certified in forensic psychology, but you're also board certified in clinical psychology. Is that correct?
Objection, Your Honor, asked and answered.
That's correct. Both of those by the American Board of Professional Psychology, which is the board certification organization that's recognized by the American Psychological Association.
So you were asked about being paid by the prosecutor. Has that payment in any way affected your testimony and your honest opinions?
No, sir.
Judge, I'd pass the witness.
I have a couple of questions, John. Dr. Cunningham, since 1974, how many prison escapes from maximum security facilities have you recorded?
I don't have a total that I can give you. I know they're infrequent, but I can't give you a total in the United States since 1974.
Do you have any statistics on former law enforcement inmates who murdered their own child?
I do not,
Now,
not that specifically.
Dr. Cunningham, do you believe that there's a case out there that based on the evidence presented, that it merits the death penalty?
Objection relevance, Judge.
What was the question?
Do you-
It's like merits.
Do you have it written? That there's two possibilities for a convicted capital murder: life without the possibility of parole and the death penalty. Do you agree with that?
Yes.
Do you agree that in some situations, the evidence and facts support life without the possibility of parole? Do you agree that there are some cases that the facts and the evidence merit life without the possibility of parole?
Yes.
Same objection, Judge. Merits.
Do you
Support.
support?
Either one. This isn't, it's not what he's been called to testify for. It's not his area of expertise. The question doesn't even make any sense in context.
Yes. Dr. Cunningham, can you, based on the merits of the case, the facts and the evidence that's produced or introduced into evidence, do you believe that there's a case out there that the special issues, number 1 and number 2, could be answered? Yes and no.
Yeah, Judge, objection, his opinion on whether there's a. No further questions.
Thank you. Dr. Cunningham, you are excused. You may go about your business, sir. Thank you very much. I'll take down your,
Thank you, Your Honor.
thank you, sir. And so we don't have the mic situation anymore, and I would like to call your next witness, please.
Judge, at this time, we would call Commander Hernandez.
Commander Hernandez. Commander? I don't know what his first name is. I think it's Juan, right? Bring my mic over here. Sir, almost good evening. Your name, sir? Jose Hernandez. I'm going to call you Juan. Jose Hernandez, please raise your right hand and be sworn.
I swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir.
Please have a seat right over here. We're going to go ahead and take all that down. We don't need that. Let's see. Let me jot down what we don't need. In fact, I think I'm just going to take everything down here. Yeah, I'm going to take down the Zoom application only because we don't need that right now.
I left the meeting.
And can you take oh, you guys are on, I think, right?
Oh,
So we're going to change it to the document image, but don't worry. Thank you. That's gone. That's fine. You're good. Okay.
You've introduced yourself as Mr. Jose Hernandez.
Yes, sir.
And Mr. Hernandez, are you employed?
Yes, sir.
And how are you currently employed?
Currently, I'm the chief of police for the Laredo College Police Department.
Could you do me a favor?
Yes.
Could you lower the mic and scoot your chair just a little bit up? Yes, sir. Thank you.
And how long have you been the chief of police for Laredo College?
4 days.
Congratulations. And before you were employed at Laredo College, what was your job?
I was deputy sheriff. Before I left the sheriff's office, I retired. I was a jail administrator.
Okay. And how long were you employed by the and I'm sorry, was that here in Webb County?
Yes, sir.
And how long were you employed by the Webb County Sheriff's Office?
Approximately 20 years.
And what was your educational background before you were hired by the Webb County Sheriff?
Before I was hired, I just had a high school diploma.
Okay. And well, did you seek education while you were employed at the Webb County Sheriff's Office?
Yes, sir. Throughout my career, I obtained a associate's degree for criminal justice from Laredo College. And then I proceeded to get a bachelor's degree in criminal justice and a master's degree in criminal justice from TAMU.
Okay. And so does that mean the first time you were hired by the Webb County Sheriff's Office, that was about in 2005? Is that correct?
Yes, sir.
Now, what was your position when you were first employed by the Webb County Sheriff's Office?
I was a correctional officer, supervisor.
Okay. And then did you move through the ranks?
Yes, sir. I promoted to sergeant and then lieutenant and then eventually jail commander.
Okay. And at a certain point, did you say you were a first line supervisor? Is that correct?
Yes, sir.
All right. And what were your responsibilities while you were a supervisor?
So as a supervisor, I was responsible for a shift of 30 officers and enforce rules and regulation, mostly the intake and release department, but overall jail operations.
Okay. And at a certain point, did you change positions at the Webb County Sheriff's Office?
Yes, sir.
Okay. And what was that new position after being a frontline supervisor?
When I promoted to sergeant, I ended up being transferred out to an investigator.
Okay. And about what year was that?
2019.
Okay. And did there come near the end of 2021, what position did you hold? Did you hold a position at the Webb County Sheriff's Office?
Yes, sir. 2021, I promoted to jail administrator, the rank of commander.
Okay. And what does it mean to be the commander of the Webb County Sheriff's Office?
You oversee oversee jail operations and its totality. I was responsible for approximately 170 employees, officers, and support staff, and then inmate population of approximately about 580 inmates.
And did you report to the sheriff?
Yes, sir.
Okay. And being the commander, does that mean that you were in charge of the entire Webb County Jail?
Correct, sir.
Okay. And are you familiar with Ronald Burgos-Aviles?
Yes, sir.
Okay. And do you see him here in court?
Yes, sir.
Okay. Could you identify him by an article of clothing?
Yes, sir. He's got a gray suit and a light blue
I'd ask that the record reflect proper identification, Your Honor. Now, during your time as commander of the Webb County Jail, did you become familiar with Ronald Burgos-Aviles?
Yes,
Okay. Now, did you know him well?
I wouldn't say so. I don't know
Okay.
more.
So in what way did you become familiar?
Because of his case and the high profile case that it was, and the attention that we needed to make sure that we were able to keep him in isolation and then transfer him out to a PC cell. And just it's different for people in his case.
Okay. Now, you've had a career in law enforcement. Yes, sir.
Yes, sir.
And you're not a friend of a convicted capital murderer. Is that fair to say?
Yes, sir.
Okay. And you're appearing here because I subpoenaed you. Is
Yes, sir.
that correct? So you're not here to do any favors. Is that right?
Yes, sir.
Okay. You're here to tell the truth.
Correct.
Is that right? Okay. Now, could you tell us where, when Mr. Burgos-Aviles was first arrested, where he was housed within the Webb County Sheriff's, in the Webb County Jail?
He was housed initially in an isolation cell.
Okay. And is it unusual for someone to be housed in isolation?
No, sir.
Okay. Why is that?
Depending on the intake process and how he's classified, that's where the inmate is placed in.
Okay. And what was it about the classification of Mr. Burgos-Aviles that made him put in isolation?
Initially, because he was a law enforcement plus his charges.
And to your knowledge, was Mr. Burgos-Aviles ever housed in isolation for disciplinary reasons?
No, sir.
And is there a point in time at which Mr. Burgos-Aviles was transferred from isolation?
Yes, sir.
And where was Mr. Burgos-Aviles transferred?
To a protective custody cell.
And what does protective custody cell mean at the Webb County Jail?
Well, it's and then in this case, he ended up in an 8-man cell. If you can picture 8 individual cells facing each other in the same housing unit, but everybody's inside their cells.
And is there an opportunity in those 8-man cells for the inmates to interact?
Yes, sir.
And is there like an open bar where they can mix together?
Yes, sir. So this jail is an old jail. So the doors, there are not solid doors like you see here today. There are open bar concepts. So that's how that setup is.
So even though they're in what we know as protective custody, is there the opportunity for inmates to fight with each other or for violence between inmates?
Yes, sir.
Okay. And are fights common, or do they occur within in those protective custody cells?
Yes, sir.
Now, and you've already told us that, well, I apologize. Let me back up a little bit. Are you aware of any fights or altercations between Mr. Burgos-Aviles and other inmates while he has been in jail?
No, sir.
Okay. Are you aware of any assaults or violent behavior towards staff by Mr. Burgos-Aviles at the Webb County Jail?
No, sir.
Now, is it common for inmates to get in disciplinary trouble while they're housed at the Webb County Jail?
Yes, sir.
Okay. And what kinds of activities could get an inmate into disciplinary trouble?
When they don't follow verbal posted rules.
Okay. Now, are you aware of any violations of disciplinary rules by Mr. Burgos-Aviles?
No, sir.
Okay. And I mean, there are a lot of people at the Webb County Jail. Would you be aware of every single inmate's disciplinary history?
No, sir.
Okay, but in a high-profile case, would the people who worked for you report to you if there were disciplinary problems?
Yes, sir.
And during your time as the commander of the Webb County Jail, are you aware of any reports of violence by Mr. Burgos-Aviles towards anyone?
No, sir.
Are you aware of any acts of disturbances in the 5 years that Mr. Burgos-Aviles has been in jail?
No, sir.
Are you aware of any threats to inmates or staff in the 5 years that Mr. Burgos-Aviles has been in jail?
Objection, Your Honor. Asked and answered.
It's a different question, technically. Well,
No, sir.
and I assume within the 18 years that you worked at the Webb County Jail that you came in contact with a lot of inmates. Is that correct?
Yes, sir.
And do you consider it significant that in the 5 years that Mr. Burgos-Aviles has been in jail, that he has a very minimal disciplinary history?
Objection, Your Honor. Cause for speculation.
I'm not aware of any incidents that he might have been involved or not, sir. I don't know.
Well, are you aware of any complaints by correction officers or jail staff about Mr. Burgos-Aviles?
No, sir.
And let me ask you, are there female correctional officers in jail?
Yes, sir.
Okay. And do female officers perform the same duties with respect to inmates as their male counterparts?
They do, sir, with the exception of strip searching.
And to your knowledge, has any female officer expressed concerns for their safety because of Mr. Burgos-Aviles?
No, sir.
Based on your knowledge of Mr. Burgos-Aviles, does it seem like he has a problem following rules?
Not that I'm aware.
Objection. Again, it calls for speculation.
If he's aware of it. Have you ever observed Mr. Burgos-Aviles being uncooperative or discourteous with correction officers or jail staff?
Not that I'm aware of, sir.
Okay. And would it be fair to say that in the Webb County Jail, Mr. Burgos-Aviles has adjusted to the environment there?
I wouldn't know, sir. I mean, he was there for a long time, so the time that I interacted with him was sporadic and here and there.
I'd pass the witness.
No questions, Your Honor. Congratulations.
Thank you. Thank you, Judge. You can go about your business. Thank you. Thank you for making me. Good to see you. Approach, please. Members of the jury, we are going to call it a day. It's been such a topsy-turvy type of day that I think we will put it behind us. You know, we're going to stick around and make sure this mic thing is figured out. And I don't think we have another. Oh, is Dr. Anderson going to be on Zoom as well?
Yes, sir.
All right, thank you. So we'll figure out the mic situation. Thank you. All right. So I am going to instruct you all and remind you of the instructions once again. Folks, it is imperative that you listen and that you comply. It was imperative that you comply from the very beginning. I'm stressing it now. You know the type of coverage, or you've probably heard of the type of coverage that there has been involved in this case. No one should be contacting you about the case. No one should be trying to talk to you about the case. If anybody does, please tell them to stop. If it continues in some sort of way, please tell them to stop and let me know at once. That's contact by you means personal contact, phone contact, email contact, social media contact, anything. And by the way, things may pop up on your social media. You have no control over that. There's the algorithms that are involved in what pops up. You need to not click it on. Some of the stuff there may be stuff that you already you got to hear firsthand. So you don't need to review any of that. You just do not click it on. And because clicking it on would be a violation of my instructions. All right. We will see you tomorrow. Have a good evening. 8:45. Thank you.
Okay, and that concludes court for today. Let's see how long. I guess it's not so much how long court was as how much my stream was. Oh, I'm not familiar with them. So anyway, we have, I guess the judge might say a few things after the jury leaves. Let's see if there's anything about that before I end the stream here. I just notified my sister, who is in town from Cleveland, Ohio, that I'd be able to come out and pick her up soon. So well, he went out of the screen and we have the wall of ham, so maybe he's not going to address people. North Korean bloke. My. Kim Jong-un. Oh no. Okay, well. Oh dear, that's a bad person to be reminded of. So, I liked how his father, the comedians would call him mentally ill instead of Kim Jong-il. Yeah, North Korea is an interesting place. Okay, well, we are done for the day, and I think that next time I'm going to set 2 alarms if I take a nap, so that I don't have this issue again. I'll be doing the other trial probably in a couple of hours or so, after I get back from meeting my sister. If anybody is still awake, and but it's been lovely to have you guys here with me, and we'll do this. We are wrapping up. Some people are thinking that the defense may rest tomorrow, so then we would see if we have any rebuttal witnesses, which I'm sure the state will. And then we'll have deliberations on whether he gets death penalty or not. So I expect things will wrap up next week. I'd be surprised if we had it all tied up tomorrow. So, well, yes, thank you. Thank you all for being here, and for understanding my little problem with the alarm clock for this stream. So, but we got it straightened out in the end. So, okay, well, we'll catch you tomorrow, if not sooner. Bye-bye.